Hey, everybody. Welcome to week 185. So, and Adam is just getting in under the wire.
Screw this up, man. I'm sorry, guys.
No, you're fine. You're fine. We're live, and that's okay.
Yeah, my bad.
You can hall pass, Adam.
Yeah.
We've been doing this for 185 weeks, and it's okay to forget every once in a while.
Yeah.
But nobody else on here is forgetting. And guess what? You're in for a treat because, yes, we have Jack, as you've known him for probably about 181 weeks because he's been on here almost since the get-go. Well, he's got a colleague named Jack as well. And so Jack Santinella pulled out the trump card and said, I've got seniority and I've got more gray hair. So guess what? Your name, Jack, is Gav.
Good deal. We'll go with that.
Yeah. So Gav, you can explain why your nickname is shortened to Gav, but he's an estate planning attorney and probably way more than that. So we're going to talk about that. And it's not something that everybody always wants to talk about. Oh, hey, let's talk about it. But with some of the stuff coming down the pike, and even if it wasn't changing, but it is, we still got to do it. It's the responsible thing to do. And even as adults, sometimes we don't want to be responsible, but man, having seen when people don't do it, or when they do and tragedy or unexpected things hit, those that didn't are in trouble, and there's no getting it back. And those that did, their loved ones and their companies, quite frankly, are thankful, because sometimes the whole place burns down when the founder leaves or something tragic happens to them. And I've seen that. And Jack, I know you have too. Gav, you probably have too. And I know Adam has. So we've got a nice crew on here. So Gav, don't screw it up. All right.
Okay, I'll try my best.
So here's the background on that, which is, it's quite practical, because if we call him New Jack, that would make me Old Jack, and I don't want to be called Old Jack. So I'm trying to prevent that nickname from happening. So I'm just being assertive and just calling him Gav. So that's what I'm trying to get done in the office and get people in the habit of that. So that's where that came from.
You're a change maker, man.
Yeah. So there is one thing that I want to bring up, and we'll go into this in more detail, but there is a new requirement that is coming out. It's called the beneficial ownership reporting by the U.S. Department of Treasury. And it's a new requirement that actually starts in 2024. It really starts in 2025, but so I'm just going to read to you directly from the U.S. Treasury report, which is beginning in January 1, 2024. Put it over here. How about this? I can look at you. Many companies in the United States will have to report information about their beneficial owners. In other words, the individuals who ultimately own the company. They will have to report information to the Financial Crimes Enforcement Network. It's part of the U.S. Treasury. Companies that are required to report are called reporting companies. This includes corporations, LLCs, or any entity otherwise created in the United States by filing a document with the Secretary of State or any similar office under the law of the state or Indian tribe, and a foreign company that is registered to do business in any U.S. state. And so there's exceptions for small entities, but the point of it is that the government is requiring people who are opening new companies to self-report who are the people behind the curtain. You used to be able to form an entity or have an attorney or CPA form an entity and not have to report as much about the underlying owners. You had to have some point of contact, a registered agent. You usually have to report at least one person as being an official person that has signing authority. But this is getting really deeper into your businesses. And a lot of times business owners don't want that to be known that they own the business. And so a lot of controversy over the past 12 months, 18 months about this. The reality is that you put these things in place and then someone has to enforce them. And then, I mean, the penalties for not complying are pretty significant. So I'm not trying to scare you into this, but it's something that it will need to be looked into if you are going to form an entity in 2024. The suggestion currently is that if you know you're going to be forming an entity in 2024, that you do it within the next 30 days, so you actually form it in 2023. And I don't know, Gary and Adam, if that's what you're hearing as well, at least the short-term solution for that. But more to come. And I will say that and BGW is not doing this to Shumaker, but there are other CPA firms and others that have said, we're not touching this. This is a legal issue. It's an owner issue. And so, let's not deal with that. Our firm is being assertive in putting together a client alert and also putting together a program across our firm to be able to assist with doing this. So that's kind of the latest and greatest on that.
Now we're gonna go heads in the sand, Jack. Honestly, what we're hoping for is there's currently the AICPA has been leading the effort within our world to lobby Congress to put a delay on the whole thing. And there's currently a House bill and a Senate bill that, God forbid Congress actually does something beneficial to small business owners, making their way through right now. So that's a long way of saying that, for us, the real impact would be a business that formed in 2024, to your point, because they're the ones that have the filing requirement that's going to occur in 2024, because everybody else that was already in existence. I think the filing requirement is it has to be done by January 2025, if I'm not mistaken. So, I don't know, because they ask to your point. I mean, the reason the CPAs are trying to stay away from it is because our lobby is telling us that we should stay away from it, because we're like, did anybody get the memo? There's a staffing shortage. How the hell are we supposed to pull this off, considering, the estimation is there's going to be, I don't know, 35 million filings in the first year. And frankly, we don't even know about ownership changes oftentimes until definitely far after 30 days that they occurred, which is when it's required to be filed. So it's, I'm sure there's probably a good intent in this one, but this is dumb. Yay, more busy work that the government's not going to do anything with.
I mean,
So-
the intentions were good in a sense that, okay, when you have people hiding behind a corporate curtain that are doing bad things, but I mean, to base and like many other things, it's let's put a band-aid that applies, or let's fix the problem by throwing this out across the board and instead of focusing on what the real problem is. And so, it's their way of saying, well, everybody has to do it. We're not picking on you. We're not accusing you of anything. We're just saying you have to do this. And then that way the government has ready access to who is behind the curtain in case there's bad things that allegedly are happening. So it gets them easier access and visibility to who are running these companies.
Not that there would be any shell companies and people in power. Like there just wouldn't be any shell companies with any of those families, name them. So that's funny. It's like, hey, you guys, we're going to make some more rules for you. And by the way, we're going to keep skirting them back, our elected officials. So Kirk has asked, so I think the first question has been answered. Does this mean that companies that were formed previously do not have to comply? It seems like that would be a yes. Is that accurate?
They have to comply. It's just they have a delay in the reporting requirement until 2025. So this is everybody. Basically, this is everybody that shouldn't have to report actually has to report, and everybody that should have to report is actually excluded for whatever frickin' reason if you go through the criteria. I mean, unless you guys have a different read on that, Jack and Jack. J squared.
No, yeah. And then the next question Kirk has about, okay, changes in ownership. Yes, And all of that they want to know who is running these companies, who owns these companies. And so change of ownerships. I mean, think about also, the companies that form special purpose entities, for buying specific pieces of real estate, and it also, as Gav may discuss, is that it applies to trusts as well. I mean, that have beneficial owners. And so this is it's very wide as far as its applicability to us ordinary people.
So what are the fees if you don't comply? You said they're substantial.
Yeah, I don't have that in front of me,
Oh,
but
it's ridiculous. It's like 500 or $1,000 a day.
Yeah.
It's
Holy moly.
yeah, like seriously, like for not reporting an ownership change on a $50,000 a year gross receipts partnership that Garrett, you're doing a great job. I'm gonna give you 10% more. Failure to report, $360,000 penalty. It's like, that's ridiculous.
Wow.
The other thing
Yeah.
to note, I think,
Yeah,
is
go ahead.
that the information, it's not the same as like information going into the Secretary of State database where your neighbor could theoretically search your entity and find information about you. This, I think, goes into some kind of limited access government database. So it's not like your neighbors could be searching or just nosy people in general. I mean, there's some restrictions on this information. I don't think it would be publicly available by any means, which is good.
So Kirk has a follow-up question, and these reports can be filed through the Secretary of State? ?
So
Yeah,
there's a separate
go ahead.
portal for that. There will be through the government agency, through U.S. Treasury. Yeah, because what you file with the Secretary of State, that is many times public information, meaning it just goes right in. It gets, the serial number put on it, and it gets put in. I mean, it is processed by a person, so it isn't completely AI yet, but it will be at some point.
So
Right.
is it just a matter of a form that you submit online or whatever, and to what you know?
Yeah, it boils down to, yes, it's a form that needs to be filled out. It because it's a federal matter, you're signing it under penalties of perjury under federal law, so it has teeth to it. So, and it needs to be properly filed. So, it's new for all of us. And how much grace is Treasury going to show all of us, that all business owners, but also the people that are assisting, so CPAs, law firms, etc., as far as not getting it right. And so, obviously, if we're responsible for that, we want to make sure we get it right. And so it's not quite clear the avenue and the path of how this is all going to happen necessarily. And so we're, as I said, we're working on putting together the internal process and protocols, but also an alert to send out to clients and others, and obviously we'll share it with you guys to share with others as well, so so that you know what's going on, and an FAQ kind of thing that we'll put out. But it's going to be a learning process, and it's also, I think, it's going to be a selective process. You cannot prosecute all of the offenders, so you do, where is the grace shown, or is it some arbitrary number that, okay, well, you got it mostly right, so we'll let it slide this time? Or is it strict enforcement? I don't think that they have the capabilities nor the monetary means to have strict compliance with this protocol. However, we move more towards, as a society, move more towards automation and processes and procedures, and picking out things and having AI spot check and then flag things for human review kind of thing. So, I think it'll be a little bit more efficient than like the PPP stuff was, just because of the passage of time and growth and advances in technology. But there's still going to be a lot of mistakes made. And who knows? I mean, with presidential election coming up is
Right.
this going to be a long-term thing, or is it going to be shut down, which would be very frustrating because, if some people would say, well, why don't you wait until we see what happens next year in November versus putting something into place, making people hustle for 11 months, and then knowing that, okay, if there's a flip at the White House, that might change.
So does this apply to single member LLCs as well?
Yes, it applies to, yes, because they're the owners of the entity. So, but there are exceptions. There's a list of 23, and I don't have it in front of me. So, I mean, but it will apply to things maybe like to nonprofits and some others, but really, in fact, I probably could pull up the list, but I don't want to go too far until we are able to present the entire picture. I just more wanted to make people aware of this, that it's really coming down the pike. I think many of us were hopeful that the can would get kicked down the road, but here we are 1 month away from the start line of this, and not seeing that happen.
So Christy brings up a good question. If the percentage of ownership changes, as in gradually selling shares back to the company each year, does the report have to be updated each time?
It's my understanding that if you are a reporting company, that changes in ownership need to be reported. Now, what I don't know is that if there is, it's a minority ownership and it's for like estate planning purposes, so you're transferring to a trust for minor children or whatever it may be. So I am waiting to be further educated on all of it as well. But
Okay.
we will.
Well, thanks for
share all of
opening the
that.
can of worms, and
Yeah,
getting
I
everybody all
know.
concerned.
I know. I didn't want to be a total surprise, just a mostly surprise.
Yeah, there you go. Well, all right. Well, that's an important thing. And that's, that was part of the impetus of us starting this thing, which was, hey, the government's changing stuff. What do we do? So anyway, let's go into a little bit more on estate planning. And Gav, you got the floor.
Okay, sure. Well, yeah, I am a estate planning attorney at Shumaker. I have kind of 1 foot in the corporate world and 1 foot in the estate planning world right now. Since I've come to Shumaker, I've been more focused on estate planning. But yeah, that basically entails, putting together wills, trusts for people. It also involves operating agreements for business owners. People don't necessarily think of those as estate planning tools, but they definitely can be. Um, and also things like beneficiary designations in 401ks and IRAs. Those assets typically pass outside of probate, and so you need to look at the beneficiary designations, because that's a lot of people's larger assets are 401ks and IRAs, those kind of assets that don't necessarily go through the probate process. But yeah, so I do all that kind of stuff at Shumaker, and I'm in my third year right now, so I'm still in the process of learning. I definitely don't know it all, but I'm enjoying it so far, and yeah, looking forward to talking with you guys about it.
Well, Jack said that you're the expert on the planet, so you've already kind of set the bar lower.
Yeah, I think it'd be helpful that just to hear, like, some people on the call, this may be, I got all that stuff covered, but it's kind of shocking, like, how many of our clients don't even have like the basic documents. Like, in other words, you need to stop what you're doing, pencils down, run out and get these documents done right away.
Mm-hmm.
Because otherwise you're being horribly freaking irresponsible, and how dare you do this to your family by not having these documents complete. What are those, from an estate planning standpoint, that you would say, look, if you don't do, if nothing else, if you don't do these, you're a freaking moron and you deserve everything that happens to you?
And Gab, before you go into that, let me
Yeah.
build a further foundation on that as well, which is
Yeah.
and my parents fell under this as well. They're like, okay, hey, something happens to us, surviving parent gets everything, gets to deal with it how they wish. If we both something happens to us and we're on a cruise, ship goes down, you and your brother will figure it out. And I'm like, okay, no. Their estate planning documents until probably about 10 years ago had my long deceased grandmother as our guardian because we were minors, had some trusts set up, and it was no, that's not the way to do it. But that is kind of the thinking, which is okay, well, I have surviving beneficiaries that will deal with it. If the law provides a pathway, which it does as a default, but that pathway is not necessarily what most people want to do for a number of reasons. There is confidentiality. So if you go down a certain way, the default way, then everything is out in the open and you have to report all that. So I just wanted to preface that I understand and I know people that have done that. But and then on the other end, so you have kids that have turned 18. You assume as a parent that you are entitled to get whatever you need to get and help that child get through 4 or 5, 6 years of college, whatever it may be for your child. The answer is that, and this happened to one of our clients, insurance company said, I appreciate the fact that you're the parent, but this is an adult and we don't have a power of attorney to be able to talk to you. So we are not going to talk to you. And this person, the kid was injured and was in a coma and obviously was not able to give consent nor sign a document at that time. So, I again understand that people have certain presumptions, preconceived notions, but so anyway, just wanted to share that. So Gav, go ahead.
Yeah, that's good stuff. And I think one thing I've heard before is that if you don't have your own will, then the state essentially writes a will for you, and those are the default rules, whether you like them or not. So you will have directions one way or another, but you might not necessarily like the outcome of those default directions that are given by the state. So obviously, one of the main documents to have is a will. Um, Other than that, there's two types of power of attorney documents. There's a durable power of attorney, which is primarily for financial matters. And there's a healthcare power of attorney, which is obviously more for healthcare issues and concerns. Both of those, definitely the healthcare power of attorney, because that becomes effective. That becomes effective once you're incapacitated and can't make those kind of healthcare decisions on your own. So that's kind of a no-brainer for having the durable power of attorney. Most of them are written such that they become effective immediately. So that's kind of a discussion we like to have with clients before they sign something like that, because you have to be very certain of who you're giving that kind of power to. It's typically something, if you're going to give it immediately, we recommend it more for older clients, that sort of thing. You can also draft one such that it springs into effect upon some kind of incapacity ruling by a doctor. But those are a little harder to draft.
I was gonna say we've all seen Rocky 5. What are when you hit on the durable power of attorney, what are some safeguards that you would recommend around that?
For a durable power of attorney?
Yeah. Yep.
Well, you could draft a springing one that springs into effect only once you're incapacitated. But as far as actually giving somebody a power of attorney, the best safeguard is to not give it unless you're 100% sure.
Yeah. So for those viewers on the call that want to know the Rocky 5 reference, in Rocky 4, as Rocky was going off to Raj to fight Ivan Drago, who had otherwise just killed his best friend Apollo Creed. He signed over the durable power of attorney to his attorney, who then ran off with his loot. So, you know, in theory, that would have been a good case for a springing power of attorney called, if I die in the ring with Ivan Drago, please take over.
Right.
You know, versus, hey, I'm just going to Russia, it'll all be good. See when I get back, don't let the house burn down.
Yeah, this is one of those moments where I never thought that anticipated that there would be a Rocky reference, and
Yeah, I pulled out.
I know.
Yeah, that was, you know, yeah, Star Wars, Star Trek, yeah, but Rocky, that is well done, well done, well done.
He's got a broader palette than we thought.
Yeah. But I would say, just as a procedural matter too, that they need to be done properly. So there is a process where it has to be notarized, has to be witnessed, it can't be related. I mean, there's all kinds of rules. So, you know, yes, you can find these forms on the internet and try to do it yourself, but you know, you're better. And again, I mean, people on this call know me. I'm not trying to upsell anything. I'm just being very practical, because like the 18-year-old thing, I didn't know. And so my daughter had her sign. My son, when he turns 18 in a few weeks, he will be in my office, and we'll be doing that for him as well, just so that we are able to be able to navigate through things. And also, you know, we had them decide, you know, for a living will. You know, they are adults, and you know, I gave them the option. I kind of and parents have mixed feelings about that, right? And they have mixed feelings about that on the other end with their own parents, as to, okay, you know, who should be deciding whether to pull the plug, literally, under certain circumstances. It's a tough decision, but it's something that should be discussed, because what can happen is that you have siblings that are not aligned with what they want to do. You have the sibling who says, no, you know, let's see advances in technology, let's try this, let's try that. And you know, another sibling that says, I know that you know, dad doesn't want this, dad is ready to go see mom who predeceased him. You know, so you get all these things. And so the point of these documents is to very clearly state what the individual's intentions are with respect to a living will, and who they trust. I will say, also give you a little bit of insight into how we did this, and hope that my parents nor my in-laws never see this. But because the youngest kid of the cousins is mine and is about to turn 18, it really becomes irrelevant. But what we did is, in order to make sure that like if something were to happen to my wife and to me at the same time, we basically forced collaboration amongst the adults in relation to our kids, meaning that one set of parents, I guess I won't tell you which set, one set of parents controls the money, one set of parents controls the kids. So one is the guardian of the money, one is the guardian of the kids, and they have to collaborate in order to make that happen. And so we thought that was a good way to kind of make sure that everyone stays involved, and that there isn't fighting amongst them as to who's going to take care, where the kids are going to live, and everything else. And so that's also relevant when there's a change in family status with divorces, and all those things as well. So also, another issue is once you draft these documents, you need to review them periodically for two things. One is change in law, but more so it is change in relationships. It is, oh, well, I had named this person as my primary trustee, and secondary trustee, but the secondary trustee is the now divorced spouse of the primary trustee. And you know, so you need to think about those kind of things too, the evolution of the people that you name in these documents. So Gav, sorry to go off on a tangent, but please proceed.
No, that's fine. And you
Wait,
mentioned, oh, go ahead, Gary.
before we jump into that, Derek Painter did make a note while we were talking about parents and all that. And he said, might be an important note, that even if you have all your ducks in a row, the Mecklenburg County Probate Office is still behind to meet timeframes as an executor, get there early and often to make sure you can meet timing requirements. Going through it now with my mom's estate as she survived my dad. So Derek, thank you for weighing in. Appreciate that.
Yeah. So maybe you could hit on, because you touched on a couple of topics there, Jack, that I think another common question that we get asked a lot, what do I mean to have some trust? Like touched on the will and the powers of attorney, and people start talking about trust, and without like a dissertation on like revocable versus irrevocable, all that stuff, can you just go into like, I got a will, I got a power of attorney. What does the trust actually do for me? Then, if I don't, if I just have the basic documents, what am I benefiting from if I then have a trust?
Okay, yeah. There's a couple benefits of trusts. One is that property that's put into a trust during your lifetime avoids probate. And that's one that a lot of people probably are aware of. So if you retitle property into a revocable or irrevocable trust during your lifetime, then that property is out of your estate for North Carolina probate purposes, and that property doesn't have to be listed.
Hey,
On
Gav, can you take a step back and define what this magical term probate is? Because I'm not sure that people necessarily understand what that means, and what you're trying to avoid, essentially.
Okay, yeah. So probate is a legal system in North Carolina that guides people through their estates or a loved one's estate. And so when property is in someone's estate at death, it has to go through probate, which is just basically a system of rules and procedures that are laid out by state law. And typically, I mean, that requires the appointing of an executor of an estate if there's a will, or if there's no will, and the person died. If there's no will, we say they died intestate, which just means without a will, and someone still has to be appointed to carry out those default rules that we talked about earlier. And that person's called an administrator in North Carolina. Some of the downsides to probate is that it can be timely and expensive to go through. It's also not a very private process. Everything has to be filed publicly. So a lot of your assets, the decedent's assets are listed publicly, as well as their values potentially. And so that's, a lot of people don't like the idea of that because they're losing a large amount of privacy. The other thing is that it's slow, and so if you have assets like business assets, sometimes those are best managed outside of probate, because you don't want a delay period where the business basically can't function in between, say, death and somebody being appointed as a personal representative or an executor of an estate. So those are a few kind of reasons why people avoid probate when they can. And like I was saying earlier, the putting property in trust is a way of doing that during lifetime. Now, if you, I'm not even going to go down that path right now. But
Yeah, and let me reiterate two things. One is that imagine, so the goal, whether it is a trustee doing it within a trust, or whoever is administering this, is to basically collect assets and pay liabilities and distribute the net to whoever is entitled to get it. And so if you decide to go the default route, which is, okay, you don't take that process out of the public eye, then everything is in the public eye, including things like your 25% ownership, your 50% ownership, your 100% ownership of a business that is listed as, okay, this, because that's an asset, right? And so the other thing is that, and correct me if I'm wrong, Gav, that, everything that gets processed, there's a percentage that gets paid out, and that's how the representative gets paid, and other administrative costs are paid, and it is very mechanical. It's a formula. So, it's supposed to represent fair market value for the services that are provided, I think. But, if you have a very large estate that's being processed, there's probably more money going to the pay for expenses than the actual expenses, really. So that's another consideration as well. So if you'll talk about, okay, so now the situation is that you do want to create more privacy, you want to extract the process out of the public eye, and then at the end, basically report back to the court to conclude the estate. So that's kind of what the process, that's what I guess optically, visually is happening, but explain kind of the trust process.
Okay, yeah. So with the trust, like we talked about, you're avoiding probate, and the other primary advantage of a trust is that you can provide some creditor protection for beneficiaries of the trust. Sometimes people think that by putting assets into a trust, they'll be providing creditor protection for themselves, but that's not really how it works under North Carolina state law. What you can do is put assets into a trust to help the beneficiaries of the trust, who are the people who are the people that will ultimately receive funds or some kind of benefit from the trust. They can, if the trust is drafted properly, be shielded from some of their own creditors. So, for example, if you want to, pass money to your kids or grandkids, but you're worried about, maybe they're doctors or real estate developers or engaged in some kind of profession that's risky, where they generate a lot of lawsuits, but you want them to be provided for. A trust would be a good option because of creditor protection. I don't know if this might be a good time to talk about the real estate issue, Jack, that we were discussing a little bit earlier. I guess it's become a trend for some married couples, to pass property, to convey property into their revocable trusts. And Jack and I were talking about that earlier this week, and whether that's a good idea or not. And the summary, I think, is that North Carolina law provides something called tenancy by the entirety for married couples owning real estate. And that's a form of property ownership that protects the property from creditors of one spouse. So let's say you're a doctor and you own property with your wife, and there's a medical malpractice suit against you. If you own property as tenants by the entirety with your wife, then the property would be shielded from some kind of judgment. But if you transfer that property out of your name and into a revocable trust, you're kind of foregoing that creditor protection, because the real beneficial creditor protection for trusts is the beneficiaries, your kids or grandkids, not yourself.
Yeah, and I will, so on tenancy by the entirety. So it basically is, I don't want to say a fiction, but it's a class of ownership, a method of ownership that allows a married couple, if the deed is set up properly. So it would say husband and wife. And so it's basically a indivisible, I guess it's a 1/2 undivided interest in the property. And so I tell clients that there should be, and I tell everyone, in my mind, there are kind of 4 scenarios that you will be signing a personal guarantee in life. One is if you're getting a loan on behalf of a company, you will be signing a personal guarantee. Secondly, if you are signing a franchise agreement on behalf of a company, you will be signing a personal guarantee. If you are signing a lease, you will be signing a personal guarantee. And the fourth is our engagement letter. If you sign our engagement letter on behalf of a company, you will be signing a personal guarantee by signing the engagement letter individually. So, but what happens in that circumstance, which is, okay, you have this, so I have a credit card in my name only, not in my wife's name. And I don't pay it, and the credit card company comes after me for many thousands of dollars. They get a judgment and they want to go get some of my stuff in order to satisfy that judgment. So for many people, their real estate is a primary asset that has net equity value in it. And so they're going to want to go after the house. If my wife is not on the credit card, in other words, she has not signed her assets as a security for collateral for that debt, then they can, I believe, put a lien on the house, but they cannot foreclose on it. In fact, they may not even be able to put a lien on the house because of her 1/2 interest, but I think they can. But they can't force the foreclosure of that property. Now, the reason why I bring up the guarantee is because if my wife has signed a guarantee in any of those 4 situations, or is a co-owner on the credit card, then yes, they could put a lien on the house. And yes, they could foreclose on the house, which would be stupid because there's usually a much larger mortgage company that's sitting on the first lien that is not going to allow that to happen for a number of reasons. But by having that tenancy by the entireties, it gives you protection. What Gav is referring to in a recent situation, it was, okay, well, we had a client that's buying some property. We had recently done some estate planning work for them. They had set up trusts in each of their names, and did the appropriate things for their children, all the things we've been talking about as far as, because they're minors. And then it was, well, I was told that we should put the ownership into the names of the trusts, but each trust should be the co-owners of this property. And so it brought up a discussion as to what is the right thing to do. And I'm going to give you the typical legal answer that I always give you. It's not advice, it's guidance, right? Because we don't give advice on this program, which is it depends. Because in this instance, this was investment property. Okay. And so they have certain advantages in doing it a certain way and the way they want to protect it. And their estate planning plans just led them in one direction versus the other. And so that's where that ended up. And, which was interesting because for me, a non-estate planning attorney, it was, well, husband and wife will always put it in tenancy by the entireties deed, and apparently that's not the case. I don't think it's a trend, Gav, right? I mean, I think this is more of an exception because I think more people want to protect that asset, the home, via tenancy by the entireties under North Carolina law. Or I don't think it's a trend. I just think it happened to be something that came up.
Yeah, the only reason I say that is because we have a colleague, a real estate colleague, who said that she's starting to see that more frequently. So I don't have any data supporting that. Just an anecdote there. The other kind of point on that is, I think it's become more popular, at least for people in my generation, for couples to purchase property before they're married. And so if a couple does purchase property before they're married, even if it's 6 months before they're married in North Carolina, they don't receive that benefit by default. And, they probably need to consider redeeding that property to themselves as a married couple after the marriage, particularly if they're, at risk for some kind of lawsuit or creditors, that sort of thing.
You had brought up something in the beginning about operating agreements and using them as an estate planning tool. And I agree with that concept, generally speaking. I'll put a little bit of a spin on that, which is I don't think you should use it as your primary estate planning tool, meaning that using the operating agreement without these other things that we've been talking about to say that, hey, I am a 25% owner in a business with 3 of my fraternity brothers. And upon my death, that, okay, my 25% is going to be purchased, either redeemed by the company or purchased by the 3 others. And then my family's going to get the money. Okay. You can put that in an operating agreement and it's a contractual obligation, but then you have this other thing going on, which is the administration of your estate, that maybe your surviving spouse says, this is a pretty good gig. I think I want to stick around and yeah, you 3 guys do all the work and I'll just, take 25% on distributions and we're all good about that. It really should be, I think, and again, this is just guidance and very general, because I have no idea what's going on within your business and what your operating agreement already says and what's going on in your personal estate planning. But I would say that, what we see as kind of the best course of action in bringing all this together is that your operating agreement is very clear as to what happens if you get hit by a bus. What happens if you become incompetent or disabled? Let's just say disabled, not incompetent, disabled. Those kind of things. What happens if you get the Italian offer you can't refuse and you want to sell? So there should be restrictions on the transferability of the ownership interest in the operating agreement. Some will go to the next level, which is, so 4 fraternity brothers and spouses will sign a spousal consent acknowledging the terms and conditions within the operating agreement that says that, yes, you will get money, you'll get fair market value for that 25%, but you're required to sell that to the company. And they agree to it at that point rather than fighting it down the road. On the other side of it, you should have estate planning documents that are very clear as to what happens with that asset that is also signed by both spouses, that would say, upon my death, this, yes, maybe everything else goes into the trust and my surviving spouse is the trustee. However, for this one asset, it is required to be sold, and then the estate will get the money related to that to distribute to the beneficiaries. Another point on that is that's the majority of cases. The minority of cases is where an operating agreement and the partners will agree. Let's say it's 4 sorority sisters, okay? And they say, well, we started this business together. We built this foundation. Let's say 10 years has passed. Their operating agreement may say that, yes, at the option of the trustee of the decedent partner, that person gets to decide whether or not that 25% interest stays within the family, meaning the beneficiaries of that estate, of that deceased partner, or will it be sold? So the decision-making process, or the decision maker, is now on the other side of it making the decision. We don't see that. I don't see that as often, but I do see that where you have people that say, yes, I want my kids to be provided for, rather than me taking the present value of the business of the 25%. I do want the 3 remaining women to work hard and give the benefit of 25% of their hard work to my beneficiaries, because I think that is a better deal for my kids than being bought out. The flip side of that is that maybe those 3 women do not want to have that person involved in the business. I mean, there's middle ground, which is they are just receiving an economic benefit. So they're receiving distributions rather than participating in the management of the business. So there's ways around that, but just understand that those are the options. And we have discussions with our clients when we're putting together operating agreements as to, these are the pathways, possible pathways, which way do you want to go? because as we said before, an operating agreement has some basic functions, which is not just governance, not just ownership, current ownership, but it's also succession and exit planning in relation to, or in the relationships of the co-owners. So that was a lot. I hit you. I mean, we could talk about this for 2 days, but I just wanted to touch on that a little briefly as kind of where the business owners, there's an interplay between the governance documents, whether it's a shareholders agreement for corporations, an operating agreement for LLCs, and your personal estate planning things that kind of merge together, where the touch points are.
So we did get a question in here from Randy. He's asking about, what about tenancy in common?
Yeah,
Do you
so
want to touch on that? Go ahead.
yeah, tenancy in common is, I guess you could call it the default rule when two people own property in North Carolina. If you buy property with your friend, for example, then you'll own that property as tenants in common. You, you own essentially a 1/2 undivided interest in the property. But if it doesn't provide the same level of creditor protection. In the example I gave earlier about the unmarried couple who buy property, prior to marriage and then become married, they would own property as tenants in common, just because they bought it before they got married. So I don't know if there's, Jack, did you want to add anything else about
Yeah,
tenants
so
in
let
common?
me give the kind of the credit card example. Okay, so yeah, Gav and I go in, buy some investment property together, and so we sign the deed. The grantees are the two of us, or our S corporations, or whatever it may be, or a corporation we formed. But so let's say we do it individually, which would be very stupid for investment property. But let's say we were being stupid and we did that anyway. So it says, yes, grantees are Jack and Jack. So I go out and I spend a ton of money and I don't pay my bills and I get a judgment against me. And then the judgment creditor is out there looking around to see what assets I have, which includes this 1/2 interest in this commercial real estate property. So let's assume that they are able to push and cause a foreclosure. And let's say that the primary lender, or maybe we paid cash for it. Okay, so there's no other lender. So this judgment creditor is first in line. They will go and they will proceed with a foreclosure unless I stop it by paying the amount that's owed. But what will happen is, let's say that they are successful in foreclosing on the property, it gets sold, and there is, let's say, $500,000 in equity. And so Gav's entitled to half and I'm entitled to half. So what happens? Gav will get his 250 and the bank will take my credit card company will take whatever I'm owed and then give me the remaining balance. So I owe 200, they're going to give me 50 back. There's nothing that Gav can do to stop that process because we are tenants in common. There is a middle ground joint tenancy with rights of survivorship, and that really focuses on what happens if one of the joint tenants dies, but it doesn't have the same protections as the tenancy by the entireties does. So those are kind of the 3 levels or the 3 types of classifications of how you would receive property as a grantee, other than into a trust, but as individuals.
All right, that's helpful. Any
Is
other
there
questions from the gallery out there?
Yeah, I was going to ask. I mean, it's been kind of quiet. There's a large group on. So if anybody has any questions, it's the time to ask, because you got Gav here that is not giving advice. He's giving guidance.
Right.
I think we could call our little segment like Gabbing with Gav. Just a thought.
Like that.
I like it.
Adam doesn't like it.
Yeah, you gotta come up with a better play on words than that, Gary.
I know. Well, what do you expect?
Yeah.
Yeah, in 5 years from now, when it's he has his own podcast, Gabbing with Gav, and then we're gonna go back to this video and we're gonna be like,
Exactly. Yeah, exactly. Yeah, that was a stupid idea. The minivan will never take off, Lee Iacocca.
Yeah. Yeah.
Well, we are hitting close to the noon hour. Yeah, you're welcome, Kirk. Hopefully this has been helpful. Oh, we got another question in here. In Under the Wire, aside from property, what else goes into a trust? Good question, Lisa.
Yeah, any property can go into a trust. Personal property, business interests, whatever you choose to put in.
yeah, I was gonna say anything, but I didn't want to have to put my foot in my mouth. But I mean, that includes things like intangibles. Well, I guess a federal trademark registration would be more tangible, but I mean, anything that you want to put in there, a pearl necklace. I mean, just anything really. But it should be, and I would say, even if a trust is created, if you have certain desires for certain pieces of property, you should make that clear. So if there's some legacy, something that you want, like, so I have, my wife has 2 sisters, and there are certain things that have special meaning to each of them that belong to their grandparents and that currently belong to their parents or other things. And so, there's, I will tell you, there's not, I don't think there's any formality to that. It's kind of just been discussed at the Christmas table, Thanksgiving table, and gatherings and that kind of thing. But it's known as to, okay, this thing is outside of my in-laws' trust, and so but the trustee would have to know that and implement that desire. If you have any thoughts or questions about whether your desires are going to be implemented, then you should make that more formal as your desires as part of your trust instrument. I think you can do that within a trust document, is be very specific with specific pieces of assets of property, right, Gav?
Yeah.
Yeah, okay.
Yeah, you definitely can. The only other thing I'll say about that is, certain business interests can't go into trust, like S corp interests, unless the trust is drafted specifically to contain those, or else you'll blow your S election, which wouldn't be good.
Okay, so almost everything.
Ooh.
Yeah.
Yeah, we don't want to blow the S election. All right. Good questions. Good crew today. And, everybody got the tryptophan out of their system. That's good. Everybody's awake again. Hope everybody had a good Thanksgiving. I'm going to go ahead and call it a day unless there's one last question that wants to squeak in under the wire. But we'll be back next week for week 186, Lord willing, and we will put this up on the BGW CPA YouTube channel for anybody that missed the front part of it, because you don't want to miss the front part of it. Actually, there's a lot of meat on the bones early on, and not just the normal fun and frivolity. So anyway, thank you, Gav. You did a good job. Thank you for joining us. Appreciate that.
Thanks, everybody. Thanks for having me.
I appreciate it. See you guys.
Yes, thank you.
All right, guys, have a wonderful day.
All right.
All right,
Thanks.
Bye-bye.
see you. Bye.
Bye.